Preston Byrne is a prominent crypto lawyer and CoinDesk columnist, and he wrote a piece that was titled Ripple Labs Ruling Throws US Crypto Token Regulation into Disarray. And his take, following on from what Will said there, is that this was very much a split decision. And if you really look at the judgment on that key question of whether tokens are securities, and if you're expecting regulatory clarity from that, I think you're going to be disappointed. Because on the one hand, it's saying that XRP is an unlawfully sold investment contract when it's sold to VCs or institutional buyers, and the court case found $700 million of that. And on the other hand, it's something else when sold anonymously via cryptocurrency exchanges. And the kind of market action is all on that kind of second point, on that question of vindicating the idea that it can be sold on cryptocurrency exchanges, but other types of sales were very much done down by this ruling. So on the central question of whether XRP is a security or not, it's very contradictory. And Byrne also points out that the judge in the case, Annalisa Torres of the Southern District of New York, some of her statements actually contradicted some other judgments that the court has made on these very same matters. And he argues, as Will was just saying, that these rulings aren't really final in the sense of being law or being, the final statements on this, because they're likely to be heavily contested on appeal, and they could well be reversed. So the takeaway here is that, this might be good for prices in the crypto market in the short term, and we all love the XRP army and the kind of passionate fan base that it has. But maybe these buyers are kind of reading the headlines here rather than the whole story. And, the real point here is that, the kind of mixed message that's coming from this single case and a single court is no substitute for a deliberative lawmaking process in Congress. And ultimately, only Congress can decide on these central questions of securities. And, regulators can't do it and judges can't do it. We really need politicians to do their damn job, really.
I am with Preston here, and I guess I'm with you too, Ben. And Will, in some way, but you said that we have more clarity. I don't feel like we do. I feel like the argument that Preston outlines in this op-ed really just explains it so beautifully. We see some exchanges saying they're going to relist XRP. Then we look at the exchanges that delisted some of the tokens that were mentioned in the Coinbase and Binance suit, and we look at what the judge has said here, and it doesn't really make sense to me, right? Part of the Howey test is can you derive profit, or I don't have the exact language here, but can you expect profit from the actions of a third party? And I think that when we look at Ripple Labs and XRP, retail investors can, right? We look at what Ripple is doing. We look at the projects and the products that they are launching. Of course, at least publicly, they really try to distance themselves from XRP when they're talking about any of the projects and products that they're launching. But if we just look at how the market reacts, of course, it's on that news. And so I don't think it's as cut or dry. And I think that we're going to see a lot of back and forth, just as Preston outlines in the op-ed. Will, what do you think?
Yeah, I agree with you. I don't think it's as cut and dry, and that's why we have this dispute right now. What is a little bit more clear from this person's one opinion, this judge's here, is that the programmatic sale or the sale of cryptos on exchanges is essentially what that means, is okay. And that's for the time being, right? There might be an appeal to that. There might be a different process. As this op-ed does lay out really well, the fact that we have basically two different opinions now. You cannot sell this cryptocurrency or unregistered security, whatever you want to call it, to institutions. You cannot just create it and sell it off. But you can airdrop it, or you can give it to insiders, or you can list on an exchange and sell it under what they're saying right now. So I would expect that to change, but I would not expect something else to change, though, and that is the fact that while these tokens are probably going to continue to sell on exchanges because they might be seen as commodities, or we might have some actual clarity from Congress in the near future. There's some bills already in the works that are getting some steam, especially with more court cases we're seeing, especially with the pressure on Gary Gensler and the SEC. So we might see some clarity on that in the near future. I want to read one quote from this piece from Stephen Palley, who's a colleague of the authors of this original piece, saying in a tweet, "The order in the Ripple case is a partial summary judgment from a single district court judge. While persuasive, it's not binding precedent on other courts and will likely be appealed and could be reversed. Don't YOLO into anything based on that decision." Going back to the price action, definitely a lot of YOLOing going on, right? A lot of longs are going into this, and that's part crypto for sure. There's a lot of gambling in crypto, so it's not unexpected. But for anyone out there who's taking a position and multiple tokens based on this court ruling, I would say maybe wait a little bit longer and find out more of the facts along with the rest of us. Jen?
Yeah, I think that the one thing that has been consistent amongst many of the people who are speaking about this is that this is not precedent setting. Yes, it will be referenced in many of the other lawsuits that we're going to see play out, but it's not precedent setting. Anything can happen. And so we'll just have to wait and see. With so many stories that we cover in this space.